I hope everyone got some sleep last night. Late night for the game? I was up later. Attendance is on. Please check in. Any questions in your minds? No questions. None. Okay. Your grades we ready to pick up on Monday around 10 o'clock. So please have your exam number ready. What's that?
Did I win the ticket?
You have to find out when you get the paper.
I need to know now.
I'm not. You think I'm that easy? No. Let's see. Any other questions unrelated to Alexander Hamilton? Always talking about Hamilton way too much. Anything else? Okay. Let's start a question for today. Okay. Here's your question. Wrong one. Wrong window, I'm sorry. Here we go. Okay. Here's your question. Okay. Under the police power, a city can exclude unwanted groups. Okay? Start polling.
Can you move it to the right a little?
Yeah, I'd be happy to. There we go. Thanks. Yeah, that screen, I have no idea what's up, so I just have to compensate over it. So that's your question. Okay, give another 10 seconds or so. All right, stop it there. Who's next? Where'd you put?
I put true.
Okay.
And I'm not sure if this is part of the, or this is kind of the point of the question, but I put true because although I don't think that they can come out and just say this is, we exclude hippies for any reason, they can essentially accomplish that by making ordinances that prevent all hippies from.
So what if they just passed a statute that said, in order to live in this neighborhood, you must make at least $100,000 a year? That's what the ordinance says.
They couldn't do that.
They could not.
No.
But what can they do?
They can make the property taxes high enough to where.
Well, we're not talking about taxes, we're talking about zoning, right? What can they do instead of saying minimum income of $100,000 a year?
No more than 4 people in a house must be related by blood.
And what's that basically accomplishing?
No hippies.
You're really hung up on hippies today, aren't you? Right? Okay. John Paul, what's your take on this question?
I put true.
Okay, why'd you put true?
Because municipalities can, for the purpose of maintaining the well-being of families and family values, enact regulations that indirectly prohibit other groups.
All right, Lauren. Not asking about Hamilton here, but what's your take on
I
this?
put false.
You put false. And why do you put false then?
Because I'm black and I know that from living in your area.
So what prevents that from happening?
The equal protection clause of the Constitution.
So could an ordinance say no African Americans live in this block?
No.
What can they do?
I mean, they could try to say, oh, well, if you make this amount of money and you have a 2-parent household, stuff that African Americans may not generally, that doesn't mean that all of us can't.
Just something. Yeah. Fair answer. I think it's a fair point. So let's see what the results are. Let's see what the poll of the whole the class says. Oh, it's pretty close actually. That's pretty close, closer than I thought. Yes, about 53 said, okay, who put C?
Nobody.
You said it jumped up, didn't it? For a second. This is the ghost of Alexander Hamilton perhaps talking to us. This is pretty close though. So I think the answer is explicitly no, but indirectly probably. And what we've seen in cases beginning with Euclid, right? The pig in the parlor. They refer to apartments as parasites. Remember that? Right? And even today, in the Edmonds case by Justice Ginsburg, she cites the pig in the parlor law. So, despite the fact I think Lauren is exactly right, you can't go out and just say, we want to keep a certain group out, we want to keep a certain race out. That can be accomplished by different means. And just look at how we've done it in cases so far. In Euclid, by zoning something as, say, one-family residential, you're excluding apartment buildings. Right? Generally, people who don't have as much money live in apartment buildings. That's just how they have to live. So they can't live in certain areas. And then we go to our class last week with the Village of Belterra v. Boras. This is Thomas's favorite hippie case, right? By limiting the number of people limiting the number of unrelated people who live in a given place, you're in effect limiting who can live there. So if you're like, the Brady Bunch with like 80 kids, you're fine. But if you have 3 or 4 people struggling to get by, spending all the money on Grateful Dead tickets, whatever, right? Then they can have the sort of communal living. But in Belterra, they said that's not permissible. Okay? But then we come now to today's reading, right? And I think today's reading illustrates what I would probably call the underbelly of zoning law. The Mount Laurel case, which I know it's long, I don't like reading long cases, but I assign it every year for a very explicit reason. It illustrates with precision how zoning laws can be crafted that on their face look pretty normal, but when they're applied, have the effect of keeping certain types of people out of neighborhoods. Right? That's the reason why I assigned this long case for you. Right? So explicitly no. The answer is false, right? They can't. But indirectly, they do. Any questions on that so far? No? All right, Justin. Let's start with the Edmonds case, right? The Ginsburg opinion.
All right.
Well, first of all, let me. Okay, give me the facts first. I'll interrupt you in a minute.
Yeah. So the city of Edmonds enacted this ordinance to define who can occupy single-family homes. It stated that you can either be related by blood marriage or adoption, and those who could live together, or if unrelated, it had to be 5 or fewer persons.
Okay, very good.
So then we had in 1990 this house, or Oxford House, opened up like a group home for recovering alcoholics and drug addicts. And they opened this in a single family home in Edmonds. And they had, I believe, like 10 people living in the house.
Not related.
That were unrelated, correct. So it was over the 5-person limit.
Very good.
And then so they sued the city of Edmonds to say discrimination under the Fair Housing Act, that the recovering alcoholics were considered handicapped.
Very good. Thank you for the summary. You didn't even give me a chance to interrupt you, but I may come back to you later. So here's what we have, right? Not too uncommon. Edmonds wants to open up a group home for recovery. And basically what this is if you're an addict, you can't be trusted to live on your own. So you live in this group home where they keep an eye on you. And what does that mean? They impose a curfew. They do random drug tests, right? They do various things, hopefully to help you keep clean. Sometimes a person's released from prison, they can't be released right to their own home. They're released to what's called a halfway house. You hear this, right? Basically this, right? So they're under supervision to make sure they're not breaking the law, make sure they're not going to get into trouble. Do these things always work? Of course not. But it's a way to give someone perhaps a little bit more help than they would have otherwise on their own. The city of Edmonds learns about this home, but they have a statute in the books that limits the number of people who can live together based on whether they're related. Okay? Now, Elena, let me ask you a question. Didn't we just read last week, Tuesday in class, the Village of Belterra case? And didn't the court say that there's no problem with limiting the number of unrelated people who live together? Wasn't that the holding of the Village of Belterra case? Then why isn't this case 9-0 rule for the city? Done, done, done. Why is this case any different? They're just limiting, they basically copied the Belterra housing code. Why is this case any different? Okay, none?
I don't know, because of it's not just about like how many people are living in the house, it also has to do with the discrimination.
What, now let me ask you a follow-up question. In the Village of Belterra case, what did they assert was being violated? What provision of law did they think was being violated? What were we talking about last class? What is it?
I don't know, but I'm assuming like probably the 14th Amendment or something.
Well, you're actually very right. It's a 14th Amendment, but which aspect?
Due process of equal protection.
Due process is half right. What was Justice Marshall's dissent to that? Do you remember?
Zoning board can set height and everything.
No, there was a baseball game intervening between Tuesday and Thursday.
I have in my notes like the zoning board can set height and other building measurements.
No. Megan?
Oh, I agree. I wasn't here for that class.
Oh, come on, guys. You gotta do better than this. Isaac.
Justice Marshall talked about the First Amendment right of association.
Yes.
And decide who you want to spend your time with.
Right? Marshall's dissent was saying that this violates the First Amendment right of free association. You can associate with who you wish. He was in dissent, right? The majority said that there are no First Amendment problems with these sorts of laws that limit the number of unrelated people. Now, Megan, did you do the reading for today?
Yes.
Okay, good. Why is this case different? Why is this case not just governed by Belterra? Why is this case different? Come on, this is such an easy question. Anthony.
The Fair Housing Act?
There's a statute! Did any of you read the freaking case? This is embarrassing. You need to do better than this. I'm sorry. 4 people in a row, not good. There's one professor at this school, I won't say her name, but she has a policy. If 4 people are unprepared to vote, she dismisses the class. This will be on the exam. This is embarrassing. Don't do this again. Read. So Anthony, tell me about the Fair Housing Act.
The Fair Housing Act was passed after Belterra, so it prevents discrimination and
On the basis of what?
race
And?
income inequality.
No.
No.
Relevant to this case, what does the Fair Housing Act prohibit?
Handicap.
No.
Disability. Sorry.
Okay. So the Fair Housing Act has a lot of provisions. Okay? Fair Housing Act has a lot of provisions. It prohibits discrimination in housing on the basis of race, religion, national origin, sex, and disability. Now, Robert, what does it mean to say that when you're creating a zoning code that you can't discriminate on the basis of disability? What does it actually mean? What's it actually mean to have a housing code that discriminates on the basis of disability?
I guess if they're placing a significant burden on these people and they're not, I guess, allowing them to live in a place.
How does putting I think you're on the right track. Let me ask this question differently. How does putting limitations on these group rehabilitation homes disadvantage disabled persons?
There aren't that, I guess, that many of these types of homes in that area.
Good.
So it limits their, I guess, access to help.
Very good. So the argument's this, right? They want to build a rehabilitation home in this area to help certain people out. The city is putting all these burdens on the ability to construct these homes. Now, Robert, just finish it up for me. What did the rehab home ask for to try to get around the zoning restriction? What do they request?
I'm sorry. They were asking who?
What did the home, the Edmonds home, request?
Oh,
They weren't going to comply with the statute. Megan, you have it? They requested an accommodation. Very good, right? Under this act, the Fair Housing Act, the city is obligated to provide what's called a reasonable accommodation, which is basically an exemption, right? Called a variance, maybe, if you want to put it in terms you're familiar with. But they want to base an exemption from the normal rules. They look, we know that your rule says 5 unrelated people, but under our plan, unless we have, 8 or 10 people, it won't make sense, right? We can't have home, it can't be profitable with too few people. We need staff, right? You need a certain number of people to be paying the bills. So they asked for an exemption from this rule. Okay? William, did they get that exemption?
No, they did not.
Instead, what did the city argue?
They used, I think from what I understand, the family provision.
Okay.
Basically say that, I'm sorry, you can't have this.
Very good, right? So, just give me a little bit. What's this family provision? You're absolutely right. That's the right answer. But what does this family say?
Well, basically, it defines a family as persons related by genetics, etc.
Right. That's the local statute. But what about the federal Fair Housing Act statute? Do they rely on?
Oh, they use it to basically restrict the maximum occupancy, right?
Okay, good. So under the Federal Fair Housing Act, there's a statute that says, as a general matter, right, if a local government enacts a zoning code that limits the number of people who can live in a home, that's exempt from the discrimination provision. What does that mean? So long as you draft a code that's based on the number of people, unrelated people, you are not going to be sued, right? You can't be sued. You ever hear the expression a safe harbor, right? You have this in torts, right? If it's stormy and you pull into a harbor, right? That's where the phrase comes from. So the federal law creates a safe harbor. So long as you craft your statute in a very specific way, such that you're limiting the number of people who can live there, you are exempt. You are not obligated to provide a reasonable accommodation. Right? That's the federal statute. So the question before the court, does the City of Edmonds zoning code fit within that safe harbor? If it fits within that safe harbor, then this lawsuit goes away. If it doesn't fit within that safe harbor, the lawsuit remains. There was actually no dispute that people with people with addictions are handicapped. It's actually not an open and shut question. There's some dispute about that. But the city concedes that people with addiction and recovery do have a disability. You'll take disability law at some point in your careers, but the general definition of disability is some sort of condition that affects major life activities, right? So if you're in a wheelchair, okay, that's an easy one, right? What if you have seizures? Well, maybe that affects your life. In this case, if you're a recovering addict, you need to live in a home, you have to get drug tested, do these various things. It impacts the way you can go about your life day to day. You can't hold a job the same way because you have to be home at a certain hour, right? There's certain things you cannot do. Right, so the question is does this zoning code fall within the safe harbor? So Kaylee, what's the court do here?
They hope that it doesn't because they wanted to narrowly read that one exception to FHA. So they held that the family composition rule wasn't really the same thing as the FHA exception because it didn't really provide the maximum number of related persons.
Good.
That could live together. So
Right.
It's not the same.
Right. So think of it like this, right? The opinion's a little bit hard to follow. It's a statutory interpretation opinion. Let me explain it like this. If the local law said no more than 5 people, period, can live here, right? Kaylee, would that law be okay?
Yeah.
Okay. But this law does something different. What does this law do?
Well, this one just, it sets a cap on the number of
Unrelated, right?
Yeah.
So what happens if you have, the Brady bunch living there, right? With like 8 or 9 kids. That's fine, right?
Oh, I said it just 6 kids.
I'm sorry?
Nothing. I said 6 kids. But
Oh.
Sorry.
Here's a story. Okay, yeah. And really, 3 lovely kids around, yeah. Little hair of gold like their mother, youngest one, right? So, I watch a lot of Nick at Night. I don't know I was a kid. So yeah, 6 kids with 2 parents means 8, which is well. And poor cousin Oliver came and left. No one ever knew what happened to him. If you have family that's big, that does not raise any problems. The statute only raises problems if they're unrelated. So because the statute was drafted the way it was, it doesn't fall under the safe harbor. So even though in Belterra, the court said that this sort of unrelated provision survives First Amendment scrutiny, in the Edmonds case, they say it does not survive scrutiny under the Fair Housing Act. Okay? The same exact regime that survives scrutiny in Belterra does not survive scrutiny under the Fair Housing Act. It does not fall within the safe harbor. Now, Christine, here's a follow-up question. Does the city of Edmonds automatically lose this case? Does the fact that they don't fall into the safe harbor mean they lose?
I'm not sure. Yeah.
Well, I'm going to ask you, what's the consequence of falling into the safe harbor? What does it mean you fall within the safe harbor? Safe from what? Look, we're going to have World Series next week or so. This is not good. Okay, I mean that sincerely. You're going to have to do your readings. Matt,
So
what's the consequence of falling to the safe harbor?
if you're within the safe harbor, you aren't held to the restrictions of the FHA. You can get an exception.
Okay, and if you're outside the safe harbor, what happens?
If you're outside the safe harbor, then you have to pass the muster of the FHA.
And you have to make a reasonable accommodation, right?
Yeah.
This you being the city. Now, does that necessarily mean that Edmonds gets its zoning permit?
No.
Okay, and that's the important point here, right? Just because you're outside the safe harbor doesn't necessarily require that you issue the zoning permit, right? But it means you have to make what's called a reasonable accommodation. And ultimately, a court gets to decide whether the accommodation you issue is reasonable. I mean, we can imagine, right? Let's say the city gives them a permit to build a home, like in an industrial zone, right? And then the home comes back and says, wait a minute, we have a bunch of recovering alcoholics, right? They can't drive. There's no bus service out to the industrial zone. We need something in a residential area where there's bus service, right? People can get around, go to work. The court can come and say, aha, that is not reasonable, right? You're giving them a location that doesn't serve the needs of their community, of their members. So the consequence of this decision isn't that Edmonds automatically must give the zoning permit. The consequence is now a judge will decide whether a reasonable accommodation was provided.
Must be provided?
Yeah.
That's reasonable.
You have to give a reasonable accommodation, right? Once you have the FHA and you say that these people are disabled, you're obligated to give a reasonable accommodation. Now, what is reasonable, that's now a question for fact finder, right? That's a question for the court to decide. But the example I gave a moment ago, right, where they give the guy a permit to build out in the industrial zone, there's no bus service there, no train service there, there's no way for the people to get to work, these are alcoholics, they can't really drive, right, they need their license suspended. So the consequence of this is it now puts the zoning process under the supervision of federal courts. The usual rule is that federal courts do not sit as zoning boards of appeal. But once you fall within this FHA category, you're required to give these accommodations that must be reasonable. Okay, make sense? Okay, so the holding, right? The holding of the case is that because this zoning law makes reference to family and relations, it's not neutral. It's not number neutral. It's not based only on the number of people. It's based more broadly on how many related people can live together. And as a result, they fall out of the safe harbor, and the zoning law is subject now to federal scrutiny, federal court scrutiny. So, even though Village of Belterra v. Boras is still good law under the First Amendment, right? As a practical matter, it has a lot of limitations when it runs into the FHA. All right, so any questions on the first case? Yes,
I'm
Robert?
sorry, could you explain again what you mean by the safe harbor?
So the way the safe harbor works is that Congress wants to create an exception to the rule, right? You may not think about this, right? When you think of a discrimination law, you think, oh, it's a discrimination law, applies to everyone. That's not actually the case. I'll take an easy example. Title VII is a federal anti-discrimination law, which says in the employment context, you can't discriminate on race, religion, etc., right? It doesn't apply to small businesses. I'm drawing a blank on the number. I'm going to say 50. That might not be the right number. But if you're a small business below a certain number of employees, the federal statute just doesn't apply to you. Now, does that mean if you're a small business, you should be discriminating? Of course not. But Congress made a judgment that we're not going to put small businesses through the paces here. The number might not be 50. It might be smaller. I'm drawing a blank on the number. But there's a number. Okay? What they're saying here is this, right? As a general matter, communities should not discriminate against disabled persons, right? But Congress says we recognize that there are certain reasons why zoning laws would want to have maximum number of people, right? You don't want things to be too crowded. So what the court's saying here is you can restrict the number of people to avoid crowding, but you can't have it both ways where you allow the Brady Bunch to come in, but you can't allow 6 roommates to live together, right? The same number of people, they're related, it's okay. Brady Bunch, right? Unrelated, not okay. And here the court says that doesn't fall within Congress's carve-out. It doesn't fall in the safe harbor. You're outside of it. Make sense? You see this a lot in federal discrimination laws where if you do certain things right, or if you're a small business or this or that, Congress basically exempts you from the provisions of these sorts of laws. Yes, David?
Is there a minimum number of rental properties an owner or landlord has to own for FHA compliance?
Yeah, right. So let's say you're just renting out your basement, right? You're renting out your basement, and then you put up, you say, I don't want to rent to disabled persons because, I have stairs in my basement. I don't want to build a wheelchair ramp, right? If you're just renting out your basement, you're not subject to the Federal Housing Act. There's a specific number of units you have to rent out. I'm drawing a blank on the number. Do you say 2 or 3? There's a number.
I vaguely recall.
Whatever the number is, if you're above that, then you're required to be bound by these federal laws.
I believe it's, I don't remember the actual numbers, but I know you have to be in the business of doing that. And if you're not in the business of renting, you just rent out your home or a room in your house, then you're not technically in the business of renting.
That sounds right. I know generally if you have a certain number of units, you're presumed to be in the business.
Right.
That might be it. There's case law on this. If you ever want to take a class in discrimination law, I encourage you. It's a fascinating class. And it's a fairly popular area of law to practice because it doesn't require that much experience. This stuff happens all the time, and people generally need lawyers to help them with housing disputes and employment disputes. But there's a number. Below that, whatever it is, if you're not in the business, then I think you're free. But there are restrictions on advertising. So even if, say, just you have your own basement, right? If you put an ad in the paper saying, I only want white tenants, right, that's problematic. So there's all these overlapping laws between advertising and actually renting it out. But good question, thank you. All right, any other questions on the Edmonds case? So the aftermath of this case is worth discussing very briefly, right? After the Supreme Court's decisions in a number of cities, Oxford, which is the name of this home, applied for variances. And in some cases, the city was able to give them accommodations. In some cases, they weren't. So there was really a mixed bag of how the courts interpreted it, right? In some cases, they said, well, having this home out in the hinterlands is reasonable. So they didn't always get what they wanted, notwithstanding this decision. So the mere fact that you're outside the safe harbor doesn't necessarily mean they win. Okay. Any questions on that? There is one section in your book where they give a bunch of acronyms. NIMBY. Has anyone heard of NIMBY before this class? Yeah, say it louder, please.
Not in my backyard.
Not in my backyard. So there's a general sense in zoning law that don't build it here, right? You can do whatever you want, just don't build it here. So the phrase NIMBY refers to not in my backyard. There are a bunch of them, right? I'll read them for you. Banana. Build absolutely nothing anywhere near anyone. Okay. Gumby. Gotta use many backyards. Lasby. Look at several backyards. Niabi. Not in anyone's backyard. Nimble. Not in my bottom line. Nim2. Not in my term of office. Nerpy. Never in rich people's backyards. Nibi. Not in your backyard. Nope. Nowhere on planet Earth. And Yimby, yes, in many backyards. So the general notion is people don't want things built near them out of a fear that it might diminish property values, or they may not like the new neighbors and also deal with new people. As a general matter, unless you fall within these federal discrimination statutes, or if you fall within the First Amendment, which we talked about, the cities have virtually unlimited power to use zoning laws to exclude various groups. The next case we're going to read, the Mount Laurel decision, is the exact opposite. When you read this decision, the Mount Laurel case, don't assume for a moment this is any sort of majority rule. In fact, no state ever adopted it. In fact, to the contrary, this decision has widely been criticized, even 20, 30 years later, as sort of things that judges shouldn't do. But it's still the law in New Jersey. And still, decades after this case, the courts are grappling with how to manage the situation that was developed in the Mount Laurel case. There have been several iterations of it. So I want to spend some time on this today because it teaches you a lot, even though it's not good law. Don't go citing this in a Texas court. You'll be laughed at. But I want you still to understand how this works. All right, so Cody, you want to... It's a long case. Just start me off. Give me the general facts here.
Well, Mount Laurel, obviously in New Jersey.
Yep, good start.
You gotta get the basics. It was basically a small township that started developing due to its placement near major highways and improvements of them.
Good.
So they basically started to zone it for industry mainly, and then under the present ordinance, 29.2% of all land in the township is zoned for industry. They had 1.2% of the total was zoned for retail business use.
Good.
And then apparently an aspect of their zoning, quote, they had a planned unit development, which the court says the idea may basically be thought of as the creation of new towns and virgin territory. I think it was that, as I understood it, each development was consulted or created by communication with the municipal authority, I think, rather than it being explicitly laid out in advance.
Good.
And I might be misunderstanding.
No, you're doing a great job. Keep going as long as you want to.
And then, so as a result, there were 3 different projects in the southwesterly sector, and then apparently one in the northeasterly sector, and they involve at least 10,000 settled rental housing units in various configurations for 4 years. Basic expansion of living quarters, I believe.
Okay, good. I'll let you look. You're good. Thank you very much, Cody. The facts of this case are long and painful, and they're done very deliberately. Right? So here's what we have. We have this town, Mount Laurel, New Jersey. A series of lawsuits are filed by the NAACP and other civil rights groups. Now, who's being represented here? It's not just people living in Mount Laurel, and this is an important point to understand. The case is also brought by people in the surrounding areas. And what they argue is that I want to go live in Mount Laurel, but due to the housing laws in effect, I can't. There simply is not any affordable housing available in this jurisdiction. So this isn't just people living there complaining about, you know, I have a crappy house, I don't like where I live, it's expensive, right? It's people from the surrounding area who want to move there. This case, even though, again, it just involves Mount Laurel, the Jersey Supreme Court reads it to be statewide. And just to give you a sense of how big the region is, they say that effectively, if you're within like a 30-mile radius of Mount Laurel, you're within this zone. So surrounding communities, right, surrounding neighborhoods, their zoning laws are also going to be implicated by this. And just to give you a sense, it stretches basically almost all the way to Philadelphia, right? It's a pretty big sweep in South Jersey. So they sue. And they argue that the way this zoning code was structured was done in a deliberate fashion to include certain types of people and to exclude others. So, Essay, let me ask you this question. Is there any evidence in the book or in the case that the people who drew up the zoning code over a number of years stated on the record, we are doing this to keep out poor people, we're doing this to keep out black people? Is there anything in the record even remotely close to that? No. Okay. So where does the court get the sort of racial animus from when they're looking at this fairly complicated, rigorous scheme?
They get it from the closenesses between what they have pretty much restricted. So townhomes, mobile homes, these things, they say the development of these type of homes will quadruple, like, the poor and African American.
Yeah, very good. So what they're effectively saying is this: there's nothing on the face of this law. This isn't like Buchanan v. Worley, right, where they're saying just, you know, African Americans, Hispanics can't live here. But by making the real estate so expensive, one-family homes, right? You can't have apartments. You can't have trailer parks, mobile homes, right? You can't do various things that perhaps poor people are more likely to want to live in. There's one line that I always flag whenever I read this case. It says, almost everyone acts solely in its own selfish and parochial interest, and in effect builds a wall around itself to keep out these people or entities not adding favorably to the tax base. Right? And that's really what's going on. What they're saying is this regime is not necessarily designed to keep out people who are of a certain race, or that might be part of it. It's they're trying to prevent people who will contribute to the tax base. Now, New Jersey has a somewhat of a unique school system in that each municipality pays for its own schools. It's not funded by the state. So if you live in a wealthy neighborhood, the schools are fantastic, right? If you live in a poor neighborhood, the schools can be not so fantastic. In fact, there was one provision, which you might recall, that if any sorts of apartments are built, a covenant has to be recorded that if a certain number of children live there, the landlord pays into the tax base, right, how much the tuition will be for the school. That's a bizarre covenant. I'd never seen anything like that before. But it's effectively saying, don't rent this to kids. Too many kids who are going to be using our tax dollars in schools and not replenishing it back. Right, so that's the general setup, right? So, Robert, what's the legal question, right? What's the New Jersey Supreme Court upset? I mean, obviously we can complain about it, saying this is not fair, but what's the legal issue that they pinpoint?
What's the remedy?
Yeah, well, you're right, what's the remedy, but you only have a remedy if you have a right. Margaret. What's the right here? What's the violation of law?
So, on the one side, they're saying, like you just mentioned, that when the poor people come to live in this, where there's this covenant, and only one or two people can, like there's limits on the amount of children that they have, they're going to use the schools, and they're not going to be able to pay the same amount of taxes. So, again, it's property values.
But why is that illegal? Didn't we already say in class last week that regulation of property values is legitimate use of the police power? Why is this illegal? That's my question. What law is being violated here? That's what I think of that?
Well, they're not providing adequate and sufficient housing, so they say it's affecting their substantive due process and equal protection.
Good, very good. Right? So they're effectively arguing, and this isn't only under the federal constitution, right? States have constitutions also. And so what they're effectively arguing is under the state constitution that this violates the protection and the due process of law. And as they mentioned a phrase, which I don't think I've used in this class before, of substantive due process, right? This is a notion that in addition to providing procedural protections, the due process clause also provides substantive liberties, among them the right of family, right? The right to associate with whom you wish. So what's done here is that the court finds a violation of the New Jersey state constitution. This wouldn't fly under the federal constitution, not for a second, right? This doesn't work under the federal constitution. But in the 1970s, there was a very strong movement to say, aha, if the U.S. Constitution won't give us what we want, we'll just make it up under the state constitution. William Brennan, who was a former Supreme Court justice from New Jersey, went on to the U.S. Supreme Court, wrote this article saying, let's look to the state constitutions to make stuff up. And that's basically what's going on here. There's not much of an effort to explain why this is what the New Jersey Constitution requires. It's just, we are doing it, we can do it, we will do it. So they developed from this general, and as they mentioned as well, this general notion of substantive due process, equal protection, a requirement. And here's the test they give. A municipality must make it, quote, realistically possible that a variety of housing is available. I'll say it again. A municipality must make it, quote, realistically possible that a variety of housing is available. They cannot foreclose opportunities for low and moderate income housing. Okay? Now, this doesn't just mean that they're required to allow in their zoning code the construction of apartments. The court imposes obligations on the city. They say they must, quote, affirmatively afford that opportunity. Affirmatively afford that opportunity. David, what does that mean, affirmatively afford an opportunity? What are they talking about there? They must affirmatively afford an opportunity. What are they talking about there?
Like you have to you have to somehow actually provide housing.
You gotta build.
You have to build, yeah, you have to go out.
You gotta build, right? You gotta build. It's not enough to say, oh yeah, we're gonna zone this neighborhood for apartment complexes. You have to build public housing. You have to build low-income housing. That what the court's doing here is imposing affirmative obligation on the government to actually build stuff, or at least work with developers to build stuff. They're not that specific how. And this phrase, affirmatively afford, it's a similar phrase to affirmative action, which you probably studied in common law. And the phrase affirmative action means it's not enough to simply stop discriminating in employment, for example. You must take affirmative, positive steps to eradicate it. This might mean a diversity policy, might mean a quota, varying what that actually means. But here the court's saying you must affirmatively afford this opportunity for both present and prospective neighbors. Right? It doesn't matter whether this was intentional discrimination, because the effect of this policy keeps certain people out. They must build housing. And here they put a serious dent in the state's police power. And not just, again, Mount Laurel, it's this surrounding area of all places nearby. So, you should think of standing right, who's bringing this case. None of that matters here. Because they're saying basically statewide, you're now under this affirmative obligation to develop this. Right? I want you to think about this point for 1 minute. We've studied at some length this idea of property values, right? That if a town wants to keep their property values up, they can use zoning to basically keep out poor people, right? So we're asking whose welfare they're thinking of? Their own, the property value of those in this town. Everyone understand that? This decision throws it out the window, right? This decision says the general welfare is not just your town, but the entire region, right? That you're responsible for thinking of the welfare of everyone in this sweeping region when you're making your housing policy. Even people outside your municipality, people who are not paying taxes, right? See, that's the issue. You have to worry about people who don't contribute to your tax base. Not Laurel's entire zoning code is premise, okay, these are people, retirees, right? They're going to make our tax base great again, right? So we're going to think of these people. No, they're saying no. You have to think of the entire sweep. People outside your tax base, they are part of your welfare. And if you take an action that harms them, you are not acting within your police power. So what the decision basically is doing is redefining the scope of the police power to include everyone, not just those in your geographic boundaries. Okay? Everyone with me so far? So the effect of this decision is that they must take affirmative action and provide a variety and choice of housing, including low and moderate cost housing, and meet the desires of all the people who may desire to live within its boundaries, right? Not just people already there, people who may want to move in. And you can't take any action to preclude that opportunity. And oh, by the way, the courts now are going to supervise this. So here's actually the history of how this went down. In the first instance, the court said, okay, we'll let you try this on your own, but if you don't do what we want, we'll come and supervise you later. As it turned out, the city of Mount Laurel didn't really do anything voluntarily. They were kicking and screaming, right? As you can probably imagine. So this began like a 20 or 30-year process in New Jersey where the courts would literally review all these various changes to the zoning laws to make sure they're complying and providing the various amounts of housing. Right? Did it actually work? There's a study in the end of your book saying it actually suggested that it made the housing situation better and that it did make the opportunities more affordable. And despite people being afraid, saying, oh, we don't want these people in the neighborhood, it didn't really make much of a difference. So the grand scheme of things, they reached a result that perhaps was better than it would have been otherwise. But this decision created a very significant judicial mess, and the courts did not have a good time or an easy time supervising the enforcement of this decision. Okay, so questions on the majority opinion? There's no dissent. Any questions on the opinion itself? All right, so, oh, I'm sorry, was there a hand?
I have a question.
Oh, yes, go for it.
So this is a case decided under New Jersey law? What
Yeah.
other states are
Zero.
like this?
No. That I said that at the outset. This is not in any sense a majority rule. It's a very much obscure rule. New Jersey had a similar case involving education. I mentioned a few minutes ago that in New Jersey, funding for education is based on the local municipality. And effectively what the New Jersey Supreme Court held is that's unconstitutional under the state constitution. And that now, even to this day, the Supreme Court of the state basically signs off on the budget, right? Every year, or every couple of years, whenever a budget's being drafted, when it comes to education, you have to get the court's permission. It has not been a very good experiment at all. And you actually had a situation a couple of years ago where Governor Christie was threatening to just ignore the court, saying this is ridiculous, we can't do this anymore, right? They actually passed a budget, and after all this fighting, and the court just vetoed it. So, right, so imagine giving a court a veto of the budget. That part has not worked out very well. Okay. So any questions on that? All right. I want to go over the midterm a little bit now. We have some extra time. That was part of my plan for today. I'm going to post this on Monday morning, so I'll show it to you for now. What I want to do is give you at a fairly high level some of the things that you did right and some of the things that you didn't do quite so right. First off, the mean is a 294, which is just below a B. That's lower than my final exam. I usually grade the midterms a little bit tougher. So basically, the mean was below a B, so that should give you a sense of where everyone falls. First off, a number of you just blew the word limit. and that broke my heart. And they were actually decent papers. It was clear that you had a lot to tell me, but you just kept writing. So be careful at the word limit, and always be sure to read it. The question, which you may recall, was a pirate-themed question involving some buried treasure on a beach on a deserted island. When you're answering these questions, I really want you to discuss cases. I've mentioned before, very few of you did. If you want to know why your paper is a B and not an A, or maybe a C, it's because you don't talk about cases. All we do in this class is talk about cases, and not just citing Stambovsky or whatever case you want to cite. Actually discuss how a given case is similar to or different from the facts given here. So part of the fact pattern here involved an island that had a curse on it, right? It's not exactly the fact pattern in the Stambovsky case, but that was a haunted house case, but it's similar. Right? So what really makes the A to B paper is discussing cases of why something is similar or different. That's what a first-year law student, I guess now your second-year law student, right? But that's what a first and second-year law student is supposed to be able to do. Make an argument based on precedent. Merely giving me the 4 elements of an adverse possession test is fine. That's not wrong, but that's not getting you up to an A. So I want to walk through these one at a time. So the first question, you may recall, concerned adverse possession of a chattel. It was gold coins. And, yes, Lane?
Do we have to know the case name?
Yes, you do. That's why it's an open book exam. There's no reason not to. Yes. Trust me, there are very few cases in this class. Compared to like common law, where there's hundreds of cases, we actually do surprisingly few cases here, so you have to know the names. That's an open book exam. You have an index in your textbook. Just flip to it pretty quick. Table of contents works also. The first case concerned buried gold coins, and it was an adverse possession issue. So if you recall, Jack washes ashore. He sees no water. He starts digging around. He finds this gold box, a box of gold coins, and he moves them somewhere else and buries them again. So at a minimum, you should be talking about the O'Keefe case, right? This was the case involving the stolen paintings, right? That was the only case we've done involving adverse possession of chattels, so you should be talking about it. And it gave different rules of when you can start the clock, because you have this thing called the discovery rule. Okay? Now, there's wrinkles in this question. This is what I want you to appreciate. There's no doubt there's entry. Jack took the gold, he put it in his chest, and he moved it over. But the harder part is continuity, right? He was only there, I think, for 5 or 6 years, and the limit was 10. There was some discussion of whether his predecessor had it for the requisite time. Could they tack? You have to talk about privity, right? Were they in privity? And in this case, they weren't, because they didn't have any sort of agreement, and in fact, one stole from the other. Okay? There's also the open and notorious standard. This part, I think, was actually very difficult. When you're burying the gold in the sand, right, that no one can see where it is it open and notorious? I think you can go either way, because I think you can argue the nature of buried treasure is that it's hidden, right? And that, it's probably a good guess that it was buried somewhere in the sand, but argue. Also, the fourth element, talk about what's your claim of right. This was a common law jurisdiction, so you probably want to talk about aggressive trespasser, right? These are all the things you have to discuss if you want an A. Now, you don't have to hit all of them, but you try to hit most of them. Some of you just listed the 4 elements and just stop there, right? That's not going to get you a very good grade, right? A lot of you didn't even mention O'Keefe. You should discuss it for discovery rule, right? That's what's going to get you over the top. Okay? The second question, if you recall, involved trespassing claims. Now, he built his camp on the shoreline, and then remember you had to cross through the island to the stream, right, to get some fresh water. A lot of you broke my heart because you only answered half the question. I asked about trespassing in 2 different areas, the shoreline and crossing to the stream. A lot of you only answered the first one, maybe you forgot about the second one. When you do that, you start off with a 5F10. You only answer half the question, right? So let's answer them in turn. On the shoreline, we have the public trust doctrine, right? The public trust means that the wet sand is public. No one owns it. You can't be guilty of trespassing it. The dry sand, where the vegetation grows, can be owned by private property. Now, I was actually very vague with the facts. This was deliberate. I said shoreline. That would mean whatever you want to mean, right? I was deliberate on that because I didn't want to lock you in, right? Because if I said he's on the wet side of the sand, then you'd remember it. So I was trying to get you to think about it. Either answer I accept. If you said the shoreline was wet, dry, I don't care. The other part of the question, the second part, is trespassing across the island to get to the water. Now, here what I wanted you to discuss was an easement by necessity, or perhaps estoppel, right? This was the only way for him to survive. He would have died otherwise. There's no other water on the island. Now, you don't have continuity. There weren't enough years there, so you don't get prescription. So you got to go to easement by necessity or easement by estoppel. All right, those are the sorts of things I was looking for in that question. So, question for that one. And if you want to mention Ovid, right, we have cases on easement by necessity. You should mention those. Yes, Laura?
So I was confused about the shoreline. I didn't know if that was the way to drive. So in that case, you just want us to simply, if the shoreline is this, then this is the rule. If the shoreline is this, then this is the rule.
Yeah. I would even accept an answer like, because the facts aren't clear, it's unclear if the public trust doctrine applies. But I at least wanted you to recognize the fact that depending where the line was, there would be different applications of public trust doctrine. But you have to actually mention public trust. A lot of you wrote the beach doctrine. That's not what it's called. Like at least 4 or 5 you wrote the beach doctrine. That's not what it's called. Give me the name of the doctrine. Yes.
So, for the second part, the stream, you said the prescription by estoppel didn't apply?
Well, I think you can make an estoppel argument, but I think the better argument is by necessity, and even by necessity.
Okay.
I think it's a better argument.
Would you want us to even talk about it then? Or?
No. What I'm doing here is I'm giving you different things that people wrote that would get credit. But I think the better argument is necessity. Right? You have a fairly limited word limit, so you want to make the best argument you can. Okay, so let's go on to the third one. This was a foreclosure sale, right? I haven't tested the foreclosure sale before. I had something inspired me to ask about it. So if you remember, the issue of the foreclosure sale was whether it's held in conformity with the law. Like, was it properly advertised? Did it comport with notice? Okay, that wasn't a big problem here. But the second issue involved deficiency judgment, because the value of the home was, I think, it was 150 gold coins. The sale brought in, I think, was 100, which means they were 50 short, and therefore the second bank basically got out nothing. So what I want you to talk about there was whether a deficiency judgment was appropriate, and that I thought was pretty clear from the frame of the question. What a lot of you did here was you talked about latent defects in question number 3. The way the question was framed was talking about the foreclosure sale before the guy became sick. I tried to make that as clear as I could. Question 4 concerned latent defects. So if you find yourself writing about the same thing in 2 questions, you're probably answering the question wrong. Each question I write is aimed at a specific area. And you should read all 5 questions before you begin writing. So a lot of you wasted a lot of space on question 3, talking about the haunted, the spirit, whatever, latent defects. That wasn't what the question was asking for. A lot of you didn't even mention the foreclosure sale and deficiency judgment, which was surprising. So it's hard to give credit for those. So just keep that in mind when you see your papers. Anything on number 3? Yeah.
So you said that your questions will overlap, so if you talk about adverse possession in one, then we know that we're not supposed to talk about it.
You're probably doing it wrong, yeah.
Okay.
If you're answering this, if you're writing, what sometimes a student will say, which breaks my heart, is, in question 4, see what I wrote in question number 3. No. If you write that, you're wrong. Each question I'm trying to test you on a different thing, right? And actually, I'll jump at the question number 5 because of Natalie's question, right? Look what I wrote. Regardless of how you answer question number 1, discuss from policy perspective why the law should, in theory at least, recognize the claim of adverse possession, like Jack, etc. Pay attention to efficiency and fairness. I can't count how many of you repeated what you wrote in question number 1 and question number 5. You started talking about the discovery rule again and basically repeated your answer. I explicitly said, regardless of what you answer number 1, right? So you have to read the questions carefully. This was a policy question, separate from the how you answer number one, right? A lot of you just basically repeated. Somebody said, "Even look what I wrote in number one." If you're writing that, I'm not going to do that, right? That's it. I don't go back. Each question is its own animal. But I'll do number 5 here. When I talk about fairness or efficiency, these are values we've discussed in class at some length, right? You want land to be put to its best possible use, right? You don't want it to just sit there and be empty. You want someone to maybe maintain it. In terms of fairness, right? If Elizabeth knew that there were squatters on it for a decade and she did nothing, then that's her loss, right? She didn't avail herself of remedies in the appropriate time, right? I always have in all my exams, the last question is like a policy question, and I can only ask you so many policy questions, right? If you study enough of my old exams, you'll probably see them all. I mean, I guess it's going to be a new thing, right? But I'm always going to try to give you something to get you outside the facts of this case. So that's number 5. Any questions on number 5? Again, if you find yourself repeating yourself, you're probably doing something wrong. Reread the question. That's not what I'm asking for. I try really hard to make the questions separate so that even if you understand concept A and you don't understand concept B, I want you to get all of your points for A. And I want to reward.
Can you justify your policy by what's going on in the case?
Yeah, that's fine. Yeah, that's fine. I mean, I reference it, but the objection I had is people who basically just rehash their answers to number 1. Maybe they're running out of time, they didn't know what to do, they just copied and pasted, I don't know. But significant number of people did that. Yes, Anna?
Did you discuss policy without drawing it in?
That's fine. Yeah, that's fine. You don't have to do it exactly as they say. But my point is, don't just repeat the 4 elements of active possession. You already talked about number 1. You're not getting an additional point.
You didn't have to apply policy.
No. Yeah. What are the questions on the last one? All right, let's talk about number 4. This was after he became ill, and he sought to rescind the contract. And then there was a claim that they failed to disclose that the property was cursed, right? This was a takeoff on the Stambovsky case. And you recall that case discussed whether a spirit, ghost was a latent defect. But this also is whether the spirit has a superior claim, right? A couple of you picked up on that with those pretty good. Right? Is there someone who has an adverse possession claim on the property, right? Is the ghost squatting there, right? Can that even be possible? We're in a fantasy world. Anything's possible in our world. Another wrinkle concerned the fact that Elizabeth noted the spirit's interest on the deed, but it wasn't written on the contract of sale. And we talked about that. There are different standards when you're suing on a contract rather than suing on the deed. Different types of warranties apply, right? A couple of students actually picked up on that, which I was happy about. But on this one, I would accept a very wide range of answers. So long as you generally discuss the latent defects, you discuss that there could potentially be a superior interest of sort based on the spirit, and if you got the distinction between the contract and the deed, that was a good mark. If anyone, a few of you got it, a couple of you picked up on it. Yeah, John Paul.
So I had a bit of struggle with that because I wasn't honestly sure if we were supposed to take the spirit as seriously because it's not a thing.
Have you looked at my old exams?
Some of them.
I've done this before. The answer is yes. I often have supernatural stuff in the various exams. I often have time travel. Time travel is not a thing, but I have time travel exams. So take the exam for what it's worth. Always take it for what it's worth. I mean, let me ask the question like this. If your answer is, Professor Blackman, the answer is nothing because spirits are fake, right? Have you used any property law in that answer? No. That's obviously not what I'm looking for. I want you to discuss latent defects with Stambovsky. Right? And even just taking Stambovsky by itself, the judge says, whether or not ghosts are real, the seller believed they were real. That was the important fact. And here, Elizabeth put on her own deed that the spirit was real.
Well, I was actually more centered on the adverse possession aspect of it.
Go for it.
How, I could understand the latent defect portion, but the ability to possess title and spirit, I didn't know we were actually supposed to do that for you.
Okay. Well, you'll see when you look at the part. But That was a fair question. So, the reason why I'm going through this with you painfully now is to correct you. By this point, almost all of you have signed up. I think I have like 90-something in my 2 classes, so there are some time slots left. If you haven't signed up yet, you should do so. I want to meet with you and walk through your paper one at a time. Again, no one failed, so all of you are starting on a clean slate. This doesn't in any way affect your final grade, but I want you to take this as serious as you can. Yes, sir.
Did you say you were a little more harsh grade on the midterms than you will be on the final?
I usually am. If for no other reason, it gets people motivated, but the other reason is you're generally less prepared, right? Generally, by the time you get to December, you're more prepared than you are in October. So when I say I'm harsher, it's just the papers aren't quite as good. But I'll say, as a whole, no one screwed up, right? No one did, like, really bad. The only papers that got bad scores are those who blew the word limits, and that's just, those break my heart, but, live with those, yeah.
So as like, you want us to mention the case names for, like, the adverse possession of the lawsuit, since it's such a short word limit, are you accepting to say, like, this is, like, to just say the name?
Stembowski, yeah. I mean, this was a Stembowski, the athlete, it's 3 words.
And that's it, and then just go by the others?
Yeah. That's not a lot of words.
We can't just cut the first word.
You can put the first word, that's fine. I mean, if you're worried about, I mean, if you're worried about Stembowski, the athlete, adding 2 extra words, maybe, I suppose.
Right, I couldn't.
1 word is fine. I'll know what you know.
Just eliminate all.
Or O'Keefe, right? I'll know what you mean by that. Yes, no.
What was the writing at the bottom?
This is my screw up. I'm sorry. These were.
Yeah.
I'm sorry about that. When I write an exam, I make notes for myself, and I just forgot to delete those at the bottom. And I realized that as soon as I pressed, like, oh crap. So I'm sorry. That was my screw up. It didn't actually help or hurt anything. I don't think it. See, actually, I originally had a recording statute question, which I took off. This is like, the director's commentary. Like, I spent maybe a day writing these questions, and my original question had some measure of damages, marketable title, there was a delivery issue with the ghost and death. I have lots of things, and sometimes they work and sometimes they don't, so I cut them out. But that was my notice to myself, so I'm sorry about that. That was my script. I won't happen again. But thank you for asking.
I was just curious.
No, those are my notes to myself. The earlier versions of this question had a very different direction, and I look at it as like, well, that's not going to work, and that's not going to make sense. I put a lot of time to these questions, and I frame the questions very deliberately, because I don't want to have a situation where it's a crappy question, and after it's like, Josh, this is vague. I was like, oh no, what do I do? So I make them as clear as I can.
Thank you.
Anything else? Yes, Lindsay.
With the word limit, like whenever you print them out, does it have how many words? Or are you sitting
It
there
does.
counting?
No, it does. It tells me the number of words. It spits it out right on the top of the page for me. It also gives me another factoid, the time that you submitted it. So I know if you left early. Oh, yeah, it went there. I know what time you started, I know what time you submitted it. So people who left early, we'll talk about that. But make sure you spend the full time. But it gives you the upload time, so I know. Okay, anything else? I can compare the times who was the latest to submit. Don't worry, I got that. Yeah, Dave.
So you once had an exam that involved time travel and the Terminator?
Yeah, I've done lots of things. Yeah, lots of movies. Anything else? All right, your exams will be ready on Monday. Appointments will be started on Tuesday. Thank you so much.